Hey, what's up everyone? My name is Isaiah. I'm with Therapy Today and I am a licensed professional counselor. So we are coming up on the 1-year anniversary of me starting this channel. So I've been thinking about where this channel came from and what's caused the channel to grow over this past year. And one of the videos that first really made it big was me reacting to a teacher who was arrested while being drunk at school. And I didn't want to be revisiting the successes of this past year by reacting to another teacher who was found drunk at school while teaching. But here we are, this woman, 57-year-old Wendy Munson, is making headlines not just because she was found drunk at school with apparently a BAC over twice the legal limit, but also that she was not prosecuted because apparently it is not technically illegal to be drunk while teaching the kids. So Law and Crime Network has a video where they are talking to a defense attorney who is going to explain some of the intricacies of the law, but I also want to talk about some of the systemic issues that lead to so many different teachers over this past year being caught with alcohol in their possession or drunk while teaching, and how we talk about supporting teachers, but what is the problem that is leading to so many teachers, and I think most of them are elementary school teachers, having these problems with alcohol. So through this video, I do want to talk about treatment, how we think about alcohol use and alcohol addiction, and maybe some of the bigger issues that might be at play here. So with that being said, please do like and subscribe so you don't miss any of our content, and let's dive into it.
Teachers have been accused of all sorts of things, right? Being unfair, being mean, being bad. Fortunately, in cases we cover here on Sidebar, there have been teachers and educators who have been accused of being sexual predators. But I will tell you, this next teacher we're about to discuss was accused of something else. She was accused of being drunk during class. And when
Over this past year, ever since I kind of hit on this true crime piece, there have been a lot of very public cases about teachers doing a lot of inappropriate things, like he talked about being a sexual predator or being drunk at school. And so I think it's fair to ask, and I don't know what the research says, whether it's something about this particular position that might attract certain kinds of people, or whether it's the stresses of the job that maybe lead people to compromise their values, or maybe it's a combination of the two. But absolutely, I think that might be something that's worth looking at, as maybe there's more public information available. But as we get an awareness that there are a lot of teachers who are not doing what they should be or doing what they should not be doing, then yeah, we need to ask the question, what's going on here in the schools?
I say class, I mean a second grade class. According to the Sutter County Sheriff's Office back on October 2nd, 2023, then 57-year-old Wendy Munson, a second grade teacher at Nuestro Elementary School in Live Oak, which is just north of Sacramento, California, was arrested. Police received a report that Munson was intoxicated, and by the way, this was just before 8:30 in the morning.
That is very early, and he's going to talk about later how high her BAC was. So we're talking about some pretty heavy drinking first thing in the morning. And so some of the screening questions that I'll ask clients, or addiction counselors will ask clients, not only how much you're drinking, but also why you drink, when you drink. Because a lot of times if you are drinking early in the morning, sometimes it's because your body no longer functions properly without alcohol in its system, that you have that physical dependence on alcohol to even feel normal. And so if she was drunk that early in the morning, that may have become something like coffee to her, where her body doesn't feel right unless it has alcohol in her system.
She was arrested for a potential DUI after the sheriff's office reviewed video footage of Munson driving to school where she failed a sobriety test. Now, she was initially charged with potential child endangerment, for allegedly teaching her second grade students.
Now that he mentions that detail, I don't know why the DUI didn't stick. If they have evidence that she drove to school on a camera and evidence that she was intoxicated at the time, I'm not sure why that charge didn't stick.
Well, drunk. After all, her BAC, her blood alcohol content, was determined to be 2 times over the legal limit. But guess what? Guess what happened? The charges were dropped. Why? Well, according to the district attorney's office, it is apparently not illegal. Right. You might be shocked to hear this. So the Sutter County DA's office, in a statement, said, quote, The mere potential that a situation could arise is insufficient to meet the requirements under the law. While teaching under the influence is highly inappropriate, it is unfortunately not illegal.
This is something that just in general I kind of joke about with people, sometimes my clients too, but you don't ever want to have a rule named after you. And unfortunately, this might be a case where she has a law because of this particular situation. That is a gaping loophole where somehow it's not illegal that she was drunk and responsible for a classroom full of children. I feel like just preventively, it's important that someone's in their right mind when they are taking care of other people's children, or any children for that matter.
Sutter County DA Jennifer Dupree followed up by saying, quote, "The behavior is reprehensible, but it doesn't violate the penal code to teach kids when they're drunk." Seems, though, that Munson is no longer listed on the school's website as a teacher, so we will see what disciplinary action results from this. But let me bring in Philip Dubé, Los Angeles County Public Defender, who's appearing in his personal capacity. Philip, great to see you. Is this true? This isn't a crime?
That's correct. The lecturer lucked out, Jesse. The way the California law is written is that you can only criminalize being under the influence in public. So, for example, had...
Wait. I'm assuming this was a public school, so I don't know how she is not in public. And it's hard to say like how you define public because she's out around people. I think of public as being outside of my home. I don't know exactly how he explains that.
She had been taking a swig from a beer bottle out in the parking lot or on the sidewalk or in the football field or somewhere like that, then that is, at a minimum, drinking in public. And that is a crime in California. But even assuming that that's what they had her on and that's what they were going to book her on, under California law, they don't put you into criminal custody for that. They bring you into civil protective custody, and they can hold you for up to 72 hours until you dry out, basically, till you sober up. And the theory is that once you have accomplished that and you don't need any additional services or help, a criminal prosecution is barred. And the reason...
That's interesting that he mentions that after the civil detainment, then if it's determined that you don't need further help, then you're free to go. And I'm curious who makes the determination, because according to him, it's now a civil proceeding. Who makes the determination whether someone needs further help or not? Because I think if you had maybe a judge versus a police officer versus a counselor evaluating her, you might get different answers to that question. You know, if you put a client in front of me and you're telling me that they were drunk on the job, they were arrested because of it, and this was all at 8:30 in the morning, that's a pretty strong indication to me that there's a bigger problem beyond just that they decided to get drunk that day.
Why is that the 3 days in civil protective custody is ample punishment, if you will, to remedy that brush. So she lucked out here. They don't have her drinking in public. At most, they have her drinking in a classroom. And unfortunately, that's not a crime.
Well, let's break that down a few things. First of all, I would imagine they don't want this to escalate to full-blown court proceedings because the courts would be flooded every 5 seconds with people who were drinking in public. I'd imagine that's why. But number two, it's a school. There's kids there. This is not considered under the definition of a public place?
No. Only if it's outdoors. Once she goes into the classroom, you are no longer deemed to be in public.
Let's say she was drinking and they were doing outside activities in the schoolyard.
Oh, then they could hook her up and haul her in for that. Absolutely.
Really? Okay.
Is this distinction the way it is in every state? I really find it hard to believe in most states that you can make that argument, oh, I was inside, so it wasn't in public, and that could actually get you off. So not to say that maybe she hasn't faced other consequences for her behavior, but definitely in terms of the legal piece, this seems like really a trivial technicality that's keeping her from facing any legal consequences.
Now she is in, yes, absolutely, they could. Yes. Now it's not the crime of the century. You know, it's drunk or drinking in public, which obviously is reprehensible, but, you know, it's not as if she's Ma Barker for doing it, you know.
You could see why people are bothered by a elementary school teacher being drunk. Now, some would say, how is this not child endangerment? So I looked up California Penal Code, you obviously know it better than me, but I was looking up 273A, and it says any person who willfully causes or permits that child to be placed in a situation where his or her person or health is endangered shall be punished by imprisonment in a county jail not exceeding 1 year, or in the state prison for 2, 4, or 6 years, I guess.
I would have thought that her drinking would have willfully or negligently placed the kids in a precarious position, and maybe that's why I'm not a lawyer. If she were my client, however, I think it would be important for her to recognize that she was very close to some of these legal charges to more fully understand the potential consequences of her actions. And I don't think she was so impaired to the point that she doesn't recognize that that's a problem. But a lot of times with addiction, and not just with alcohol, but with any kinds of behavioral or substance addictions, we get so focused on that immediate gratification, whether it's the high or whether it's the entertainment, that we minimize the potential long-term consequences of those choices because the immediate benefits feel so much more attractive, so alluring, that we compromise our ability to make those long-term choices, those what we consider adult choices, to be able to delay gratification, to be able to think long-term about the consequences of our choices.
Depending on the severity. This isn't child endangerment?
Not under California law. No, not at all. If there were reports, for example, that she was tripping over her feet, she had an unsteady gait, or that she was passing a bottle around to the kids to take a sip, that kind of thing, then obviously that's endangering their health and certainly their safety.
That brings to my mind a question then: how did they suspect that she was under the influence if none of these things were happening? Something must have tipped them off to the idea that she was drunk while teaching, and if none of those issues with coordination, balance, or any of those other things, if those things weren't happening, how did they know, or how did they suspect?
But at most, what you have is her endangering herself. And that, unfortunately, does not meet the criteria for child endangerment. The problem, Jesse, is that the legislature needs to step in and amend our education code, because there are provisions in there that criminalize the conduct of teachers. But you know what it takes? It takes these unprecedented moves, these unprecedented acts to affect change and reform in the law. And you can bet that our Assembly and State Senate will be convening to add something like this to our education code and to the penal code.
And when he says unprecedented, I think based on this year, this past school year alone, it's not all that unprecedented for teachers to be intoxicated while in the classroom. And even a lot of the comments that I've seen in the original videos I've done about the other teachers who were drunk in the school, or even on this video, it's been a problem for years and years. A lot of people saying that when they came up through elementary school, middle school, and high school, that they had teachers who were drunk all the time, and everyone knew it but didn't say anything. And so I think it is fair to ask whether it's just the higher publicity of these cases is forcing lawmakers to start responding to that, whereas it was just kind of buried before. And I do know that there are a lot of circumstances, in teaching especially, that lend themselves to high stress, with being responsible for so many kids, with being responsible to state standards, a lot of unpaid time spent in prep, a lot of financial burden of purchasing materials maybe that won't ever get reimbursed by the school system. There are a lot of factors that create this pressure for teachers, that maybe some of them turn to alcohol to be able to cope with that and be able to get through the school year. And so systemically, I don't know if the answer is necessarily just providing counseling services for teachers. First of all, you don't guarantee that all teachers will take advantage of that, or they'll recognize that it's enough of a problem that they need counseling, but also that it feels like more of a band-aid that doesn't actually fix the underlying circumstances that lead them to cope in unhealthy ways. So I think it may be beneficial for some teachers, but for some it doesn't change the underlying issues that led to this widespread problem that is now getting the attention that maybe it deserves.
Well, because this story has been amplified. It's everywhere right now. People are wondering about it. I think people are shocked that it's not actually illegal. I guess, wouldn't it matter what kind of teacher she was? Why do I say that? I said, maybe, okay, second grade teacher, she's drunk, it's inappropriate. But if she were home ec, right? You know, operating machinery, or a chemistry teacher or a gym teacher. Would it be different? Could it be child endangerment?
I think it could be child endangerment for purposes of her professional licensure. So, for example, it's not over for Ms. Munson. You can bet that this incident got reported to the California Commission on Teacher Credentialing. And what they will do is they will go behind the record and look to see whether or not this misconduct renders her unfit or immoral for teaching in a California classroom. So they'll go separate and apart from the criminal definition and try to see if they can maybe revoke her license on that basis. But I can tell you, based on my own independent research, they renewed her teaching credential in March of this year, and it's good for another 5 years. Now, it's not to say that she's teaching. My gut says that she worked out a deal with the district that she would quietly retire or step down, and that would be the end of the matter, and she could save her credential. Doesn't mean she'll ever be in the classroom again, but that's how I believe they chose to remedy it.
That's an interesting arrangement. And so I think it's important for people who have these professional identities, for lay people and the professionals, to be aware that just because you aren't charged legally, that doesn't mean there are no ramifications. So for instance, if I engaged in some kind of malpractice or negligence, even if there wasn't something criminal, I don't know exactly what that would be, but there would still be professional ramifications for me, because potentially I could lose my license or it could be suspended. And it sounds like there was something going on here where maybe she worked out a deal to not have it revoked, but maybe that she stops teaching. And again, this is kind of supposition based on what this guy is saying. I think it could be possible that because there was no official action against her, that maybe protects her from lawsuits from parents. Whereas if there was some kind of disciplinary action, either legally or professionally, the parents might be able to point to that and say, okay, see, you punished her, so she did something wrong, and therefore she has liability and we can sue her. And so maybe this is a way of protecting her. So I don't know whether that's like a union thing or just something that she worked out with the board there, but I can see how that's a way to maybe legally protect her. And lawyers, talk to me in the comments below whether you think that might be the case or whether that's just how they decided to resolve this issue. But it's interesting, some of the maneuvering that's taking place behind the scenes in this case.
After the DA's office rejected a filing.
But they removed her from the website. Does that mean because they don't want everybody to know about this, or?
Well, she's not removed from the state licensing website.
Okay.
That is public record. She still holds a teaching credential, a license to teach. Now, she might not be on faculty anymore with the school, which is separate, and they absolutely can remove her because she's no longer on payroll.
But it seems that one of the reasons they're also not feeling this is a child endangerment charge is I don't think they were able to definitively prove that she was drinking, in the sense that they looked at the video of her driving and it didn't, on the face of it, look like she was intoxicated. This was an 8-month investigation where I believe they interviewed her current and former students, I believe maybe coworkers, but they couldn't establish that she was drinking or drunk while either driving to work or if she began drinking at the school. So it also feels like a case that they just had insufficient evidence, right?
Absolutely. In order to make an arrest for DUI here in California, there has to be evidence that she was impaired behind the wheel. In other words, that she could not operate the motor vehicle safely. So what does that mean? Well, you look to her driving patterns. When she pulled into the parking lot, for example, to go to school that morning, did she sway or drift or almost crack into another car? And when she parked, did she have a hard time getting out of the car? Did she have to hold onto the door to keep her balance? Did she vomit, and have to move her feet out of the way? There was nothing in her driving patterns or in her gait to suggest that she was at all impaired from the effects of alcohol.
Again, I want to ask how they knew to test her BAC if there was nothing that indicated that she was drunk, either in her driving or in her behavior. I talked about this with Kimberly Coates, the other teacher that I reacted to who was arrested while being drunk at school, is that for people who are heavy drinkers, a lot of times you can have a really high blood alcohol content and have it not be obvious that you're drinking, maybe except for the smell of alcohol on your breath and on your clothes. There's this concept called tolerance where your body starts adjusting to just the large amount of alcohol that you're taking in. And so you start being able to look like you can function. And so a lot of the more obvious signs of intoxication aren't present when you're drunk, even though you have a really high concentration of alcohol in your body.
So then what are you left with? Well, you can do what's called the Widmark formula, or sometimes we affectionately refer to it as retrograde extrapolation, where if you take her blood, for example, or a breath test beyond 3 hours from the last moment in time she drove, and you couple that with her size, her weight, and whatever she had for breakfast, you can retroactively determine what her blood alcohol concentration was at the time that she last drove and pulled into that parking lot.
That's important to note. And I've worked with college students, so I've had to discuss this myth before, but there aren't ways to have alcohol leave your system any faster. The only reason that this test works is because alcohol gets processed at a predictable rate within your body. And so when like college students tell me about like maybe drinking coffee or showering or doing any of these things, it doesn't cause the alcohol level in your bodies to change any faster or get lower any faster. And that's something that I've had a lot of arguments and debates with clients about because they'll swear by these myths.
And it sounds like that under the Widmark formula, they could not put her at a 0.08 or greater at the time she pulled in. So that's why the DA's office likely rejected the DUI filing.
But she did reportedly fail the sobriety test. So, I mean, that's interesting. And I will tell you, do you think it was interesting that it took 8 months to decide the charges would be dropped, an 8-month investigation?
It's not uncommon, frankly, especially when a defendant is out of custody. They are so backlogged right now with out of custody or what we call non-custodial arrests that there is no rush to get those matters into court and resolved. The matters that really take precedence are the ones where they are in custody because they have 48 hours from the time of arrest to get them arraigned. Otherwise, they have to release them. So they can put it on the back burner, take their time in working it up. And if it turns out they don't have the evidence, then the city attorney or the DA's office will just simply reject it and deem it to be a labor matter. Now, make no mistake about it, she still could get in trouble with the DMV. If they have evidence that, despite the lack of a criminal prosecution, that she drove under the influence, the DMV can still suspend her driver's license. Mm-hmm. So there's really almost 4 or 5 different tracks that she's up against. Number one, criminal prosecution, that was eliminated. Number 2 is her professional licensure, which is right now probably in controversy with the state. Number 3, her pension. If she would have been convicted of a job-related felony, California has pension reform where they can forfeit your pension from the date of the crime forward. So it's the consequences they never end. And then, of course, DMV involvement. The DMV gets involved. They can actually suspend or revoke your license if they feel you're a danger to the highway and you shouldn't be driving.
I think that maybe cognitively, she knew all of these potential implications of her behavior. But what happens with addiction is that we start minimizing those potential consequences. We think, oh, I'm not gonna get caught, or like, it's not a big deal, I'm fine, I can drive, I can teach, I'll be fine, nobody's caught me before, so it's not gonna be an issue. All of these justifications that sound really dumb in hindsight because now she has been caught, but that's the kind of reasoning that I've heard and seen from a lot of people, unfortunately, that have led to some really sad consequences. And so sometimes it takes the firsthand experience of, oh yeah, this can actually end poorly, for some people to recognize that, okay, maybe that immediate benefit is not worth it.
So it's never ending. But it sounds like this lecturer lucked out for now.
Well, I got one more for you. What about a lawsuit, right? In the sense that even though charges aren't filed, we know that the standard is lower in a civil case. It's preponderance of the evidence. Could they try to, parents of these children say, we are going to either sue her or the school for allowing what they believe is a intoxicated teacher to be around our children? Would they have grounds for a lawsuit? Obviously, anybody can file a lawsuit for anything. Anybody can sue anybody, but it has to actually have grounds. It can't be frivolous. Do they have any way to file a lawsuit against the school or her on this basis, or the fact that the charges haven't been brought is a signifying to them they might not have the evidence to support it?
Well, the answer is probably not. First and foremost, they have to file what's called a notice of claim within 6 months of the date of the offense, meaning you have to put the school district and government on notice that you may have a civil claim. It's sort of a mini statute of limitations. It's an administrative claim for damages. If you don't bring that claim before filing your lawsuit, your judicial lawsuit is barred. My gut tells me they never filed the notice of claim, but let's just assume they did. I believe at most all they could get is injunctive relief, maybe seeking to get her out of the classroom. But I do believe that in terms of damages, they're immunized and there would be no liability. There's no civil rights violation here. There certainly was no corporal punishment. It was an act of negligence, and there was really no monetary harm, if you will, to the child or the families.
Well, I think I agree with you that there might be a change in California law as a result of this, and maybe rightfully so. But again, at this point, she is innocent, right? She hasn't been charged. So these were just allegations that she was drinking while at school or was drunk at school. So really fascinating case. Like you said, she is not going to be facing charges. We can kind of have a better understanding of why. But LA County Public Defender Philip Dubé, thanks so much for coming on, and great seeing you.
Okay, well, there you have it. Again, I think he makes a good point that just because she hasn't faced legal consequences, that doesn't mean there might not be other implications, like he talked about maybe with her pension or with her professional career. But the reason that I react to these videos is not to keep piling on and make one judgment about whether a teacher deserves to be arrested or imprisoned or face a civil lawsuit or anything like that. The point is about educating about the nature of addiction and maybe some of the systemic issues that might be playing into these situations where, at least anecdotally, it seems like a lot of teachers struggle with alcohol for one reason or another. And again, I don't think it's just because alcoholics tend to go into the teaching field. I don't think that's the case. But I hope by providing some of this education and framework around understanding addiction and why someone might choose to drink the morning that they're going in to teach a bunch of second graders, that we can better understand what might be going on for her, be able to better understand other people in our lives who might be struggling with a similar problem. Of course, there are tons of resources for you to reach out if you are struggling with addiction, or if someone that you love and care about is struggling with addiction. So I do encourage you to reach out to those. Those will be posted in the description below. But again, it's a sad situation that this teacher might have to face some long-term consequences for these actions, as well as for the students who, even if there wasn't any overt harm, I think there's a lot of challenge for both the students and the parents to be able to trust the public schools again, to be able to trust their teachers implicitly, like you're sending your kids off in the care of somebody that now you're not sure whether they're in their right minds or sober the entire time. So I think there are some long-term implications and concerns that these guys did not touch on, but that I could perceive based just on a mental health standpoint and perspective. But again, thank you all so much for watching this video. Please do like and subscribe. That helps our channel to grow as we head into another year of making content for you all. Thanks so much for watching this video. I'll see you all next time.